Hello, this is Rob Lambert with AssetProtectionTraining.com. Today I'm going to be talking about a very important, very fundamental concept. And yes, we're going to do some deep training on it. There'll be some 15-20 minute sessions with the codes and all the statutes and cases, and we'll be going over it in detail. It's that important. But here it is in a nutshell. There's a concept that I use. I've been using it for 25 years. Called old and cold. Old and cold matters. And why? Well, this all comes down to the most common way asset protection planning is attacked. The way a creditor, particularly an aggrieved creditor who can't get to a plan assets, because remember, asset protection done correctly, even if done for bad people at the wrong time, works. We don't want to do that. We want to avoid that. We always want to do it at the right time and make it so we can hold our heads up high. And how do we do it? Well, we do asset protection when the financial seas are calm, and we let it get old and cold. Why? Because the most common attack on asset protection plans is to argue that the transfers to the asset protection entities, remember, what you don't own can't be taken from you, the first rule of asset protection, arguing that the transfers out of your balance sheet and onto the balance sheet of a trust or another entity were fraudulent, that both before and after the transfers you didn't retain enough assets to pay your reasonably anticipated debts. And in fact, you were just engaging in these transfers to screw your poor unfortunate creditors out of their just desserts. Well, that may be true, but you always want to be able to point to the fact that your transfers were intelligent, done for reasonable reasons other than just asset protection, although asset protection is a valid business purpose in and of itself. Don't ever think that it's not a good thing to do. The main way you attack it is to claim it's a fraudulent conveyance, and then if the statute of limitations has not run, you will oftentimes see a judge order the assets returned. This is where the creditor gets some power over you, because if you don't comply with the judge's order, and if you have the power to comply, you're facing some jail time, not for not returning the money, but for disregarding a judge's order that you have the capacity to perform. Now, we'll be dealing with this in detail. There's a section on criminal contempt which goes through all the details. But you know what? Let's just avoid the issue. Do asset protection when the financial seas are calm, and let your plans get old and cold. A normally safe period is 4 years. That's the normal statute of limitations in the United States. 7 years if it's fraud. And actually 1 day is normally enough. If you do your plan and can prove that it wasn't a fraudulent conveyance, and the next day you run over the neighbor's daughter and you're facing horrible, awful financial calamity, that still should hold up. But you always should think ahead, have the courage and foresight to do it before you are in trouble. It makes it cheaper, it makes it more effective. Okay, we'll talk about this in much greater detail, and just remember, old and cold matters.